Okay, commissioners, we are ready to begin again. Are you all back from break? See Commissioner Jancy, Commissioner McCauley, thank you. Commissioner Halter, you back? Commissioner Metler, Commissioner Burke. Commissioner Metler, thank you. Commissioner Burke, okay, we at least have a quorum so we can proceed. Okay, we're moving on to the group of City of Cresswell cases, and no one is hearing on these matters, correct?
That's correct.
Okay, Investigator Sullivan, I believe you are giving this report, correct?
Yes.
Please proceed.
Yes, thank you, Chair Payne and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda items 11 through 17. This is a complaint against the city councilors for the city of Cresswell. The complaint alleges that the Cresswell City Council may have violated Oregon Public Meetings Law by excluding members of the news media and by taking a final action in an executive session held on March 16, 2026. In this case, the city council excluded Bjorn Dahlin and Stephen Roder, members of Oregon Aviation News, from their executive sessions on March 16, 2026. Excluding representatives of news media because an entity fails to provide specifically requested information is inconsistent with the AG Opinion 8291 and the AG Manual. And excluding representatives of the news media because the governing body failed to provide or verify provided information in a timely manner would appear to be violations of ORS 192-660 sub 4. Thus, when the city council excluded Bjorn Dahlin and Stephen Roder from the city council's executive sessions on March 16th, it appears they may have violated ORS 192-660 sub 2. Additionally, the executive session minutes do not contain detailed information about the city council's actions during the closed session, but it appears they may have decided to authorize the mayor and the city manager to negotiate agreements with two selected candidates for the positions of municipal judge and city attorney in violation of ORS 192-660 sub 2. The information available appears to indicate that the city council may have violated provisions of the Oregon Public Meetings Law by excluding individuals who identified themselves as members of the news media and by making a decision during the executive sessions. The recommendation is to move these cases to investigation.
Thank you, investigator. Commissioners, any questions for our investigator? Any discussion? Oh, Commissioner Gibbons.
Did they make the reporters leave, or were they just not notified?
Yes, thank you for the question, Commissioner. They had conversations and email back and forth prior to the meeting, and they told them that they wouldn't be allowed to attend, and so they were never let into the meeting.
Investigator, I'm not finding this in the report, but I believe I recall somewhere reading that we either provided an opinion or there was some other commission complaint regarding this exact issue previously. Regarding the city of Cresswell, is that in this report?
The city, you know what she's.
They called and spoke with me before the executive session was held, like early the week before, because they were concerned about. I first spoke to the city recorder and then to city manager and/or attorney. I'm not sure who was on the line, but the concerns were they were holding an executive session to meet or planning to meet with the city attorney regarding ongoing litigation. The ongoing litigation involves a breach of contract case at the airport, and the media representatives way back at the breach of contract time had been the tenants. But they are not parties to the litigation because they sold the company that had the leases, and the breach of contract was between the new owner of the company and the city. They may be interested parties, they may be witnesses, I don't know, but they are not parties to the litigation. And the exception for admittance of media, there is an exception in the statute saying you can exclude media if they are parties to if the representative is a party to the litigation being discussed, or if the paper that they're, or the media company they represent is a party. But it does not allow you simply to exclude them for any other reason if they are not parties. So in my conversation with the city in advance of the executive session, I talked about the only provisions allowing exclusion of the media. I gave them the Attorney General opinion that lays out the factors to consider in whether someone qualifies as media. And I, suggested they contact their attorney. They could potentially go to court, go to the court that is having the litigation and seek a protective order, but that under the existing statutes, there was not a provision that would allow exclusion of the media.
So just to clarify, because I have a question, even if he was a party to the litigation, that would have only applied to one of the meetings and not the other meeting?
Yes, it only applies to an executive session held under subsection 2H.
Okay.
And there were two executive sessions just substituted
Yeah.
right after each other, and only one of them was 2H, so it wouldn't have applied to the other one.
Yeah, I guess I have concern with, this may be a separate issue, but I guess I have a concern with like a corporation, because corporations themselves are, like, if he's a CEO or somehow related to the corporation that they're in litigation with, it does seem concerning that he would then be able to come in and to listen to their executive session where they're giving legal advice. But if that only applies to one of the meetings.
Right, and as far as the information provided to me was not that he is a corporate officer of that company.
There's some association, but we didn't have information that he was a party to the litigation, which is the term that we look at.
Right, but if you have a corporation, there's never going to be, an individual is never going to be a party because the corporation itself is going to be a party. So it would have to be an officer or some, that to me just doesn't make sense.
Yeah.
To say whether that individual themselves is a party, because that's not how media companies would work. So I guess to me, we're moving, like, the recommendation is to move this into the investigation, but I would like maybe more information regarding that, but
Right. I would clarify that the exception, which is in 192.660 sub 5, is if the member of the news media is a party or is an employee, agent, or contractor with the news media organization that is a party.
okay.
So it covers both bases.
Okay. Yeah, so I think that would be helpful to understand that, but I understand that there still may be a violation as to the other executive session, but I think it would be helpful to understand his particular role in the company that they were in litigation with.
Chair Payne. Be a question for Dan. Under public meetings law, an executive session cannot be reported by the press in executive session. So with that being said, even if he was a party to the corporation or had a some kind of a relationship with it, wouldn't that still protect the confidentiality of being in that meeting?
Generally, no. I mean, they can be instructed not to report on various things, but the public meetings law also will not apply to private individuals.
But he was there as a would have been there as a representative
But
of the press.
again, the public meetings law itself and, the commission's jurisdiction does not extend to members of the news media who may do something wrong. We can't do anything
Okay,
with respect to that.
so they're shielded against us.
And certainly, as if I were a public bodies attorney, a litigation counsel, I would not want to provide any privileged advice, knowing that an opposing party was present.
Right. That would not be good.
Yeah.
All right, thank you.
Commissioner Halt, I see your hand is raised.
Thank you, Chair Payne. I found this case particularly troubling on a couple of levels. Can you speak to how they made rules that they felt fit underneath the Attorney General's guidance that were specifically designed to eliminate this individual from their meetings? I was really taken aback by that. It sounds like they decided that opinion media had no relevance, and there was a couple other things. It's, we have to protect speech that we agree with and disagree with, and access to media and transparency in our governing bodies is incredibly important, in my opinion.
Yes, thank you for the question. If I understand correctly, they don't have a policy that specifically outlines the criteria required to verify representatives of the news media, but they did send emails requesting a variety of information and quite a lot of documentation from the complainant in this case, just to verify whether they were members of the news media and what OAN's role was and whether they are news media. And they provided what they determined to be a sufficient amount of information to verify their role as members of the news media. And so I think there's a disagreement there between the city and the complainant, whether that information was sufficiently provided or not.
Is this the case where they made a 30-day requirement too?
No, that's a different case.
Okay, I'm just.
In this book, but in a different case. I do want to
There was
clarify.
1,000 pages I had to read, so I'm trying to
I understand.
keep them all straight.
I want to clarify on that last point of the Attorney General's opinion that was issued is, for the most part, the only guidance we have. The commission cannot make the determination for other governing bodies whether someone qualifies as news media. But we are charged with enforcing the statute saying you have to let news media in. Does not put us in a great position. The opinion does have a discussion about a governing body can adopt its own procedures, its own policies. It can do all of those things, but then it also says, however, regardless of what your policies are, if they're news media representatives, you have to let them in. And so I think the argument can be made that a governing body cannot adopt procedures designed to prevent admission of the news media. But the opinion, which is long and dense, is not particularly helpful necessarily in saying this person is a member and this person is not. It simply says to consider whether someone qualifies as a member, you look at things like, are they news gatherers? Do they regularly report? Do they have a business structure, etc.?
Can I ask one more clarifying question, Chair Payne?
Yes, please.
When is this Attorney General guidance that we are using what's the date it was issued? I think it's particularly relevant because news is changing rapidly, and a lot more news that we are getting is from less structured news media. I don't think it necessarily applies to this case, but it's something that I really want to make sure that people have access to meetings and to be able to disseminate information in a modern way. Thanks.
The AG opinion was issued in 2016.
I think it's time to ask for an updated one because 2016 news media was very different than it is today. Thank you.
Thank you, Commissioner Halt. Any other questions for our investigator or comments, discussion?
Chair Payne, to me, there's a lot of gray here.
Yeah, I agree, and I'm inclined to vote to move this to investigation. Vice Chair, are you prepared to make a motion?
I am. Thank you, Madam Chair. I move the commission find there's a substantial objective basis for believing that Alonso Castilla may have violated ORS 192-660 sub 2 and ORS 192-660 sub 4, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda items 11 through 17. Administrator, please call the roll.
No, we have to do each of them
Separately.
separately. Sorry.
Can't do them as a-
Not at
I
this
just made a
minute.
motion on the first one.
Yeah, you did, and that was my error. Commissioners, you've heard the motion on agenda item 11. Administrator, please call the roll.
Commissioner Mettler?
Aye.
Commissioner Thompson?
Aye.
Commissioner Givens?
Aye.
Commissioner McCauley?
Aye.
Commissioner Halt? Aye. Commissioner Jancy?
Aye.
Commissioner Burke?
Aye.
Chair Payne?
Aye.
Motion passed 8-0.
Vice Chair number 12, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Joan Morris may have violated ORS 192-660 sub 2 and ORS 192-660 sub 4, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 12. Administrator, please call the roll.
Commissioner Givens?
Aye.
Commissioner Halt? Aye. Commissioner Mettler?
Aye.
Commissioner Jancy?
Aye.
Commissioner Burke?
Aye.
Commissioner Thompson?
Aye.
Commissioner McCauley?
Aye.
Chair Payne?
Aye.
Motion passed 8-0.
Vice Chair number 13, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Mark Kramer may have violated ORS 192-660 sub 2 and ORS 192-660 sub 4, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on 13. Administrator, please call the roll.
Commissioner Mettler?
Aye.
Commissioner Jancy?
Aye.
Commissioner McCauley?
Aye.
Commissioner Burke?
Aye.
Commissioner Halt? Aye. Commissioner Givens?
Aye.
Commissioner Thompson?
Aye.
Chair Payne?
Aye.
Motion passed 8-0.
Vice Chair 14, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Clark Kent may have violated ORS 192-660 sub 2 and ORS 192-660 sub 4, and the commission should investigate accordingly.
Commissioners, you've heard the motion on 14. Administrator, please call the roll.
Commissioner McCauley?
Aye.
Commissioner Burke?
Aye.
Commissioner Thompson?
Aye.
Commissioner Jancy?
Aye.
Commissioner Mettler?
Aye.
Commissioner Halt? Aye. Commissioner Givens?
Aye.
Chair Payne?
Aye.
Motion passed 8-0.
Vice Chair 15, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Alan Dukes may have violated ORS 192-660 sub 2 and ORS 192-660 sub 4, and the commission should investigate accordingly.
Commissioners, you've heard the motion on 15. Administrator, please call the roll.
Commissioner Burke,
Aye.
Commissioner McCauley,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
Aye.
Commissioner Halt,
Aye.
Chair Payne.
Aye.
Motion passed 8-0.
16, Vice Chair?
I move the commission find there is a substantial objective basis for believing that Stacy Holt may have violated ORS 192-660 sub 2 and ORS 192-660 sub 4, and the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on 16. Administrator, please call the roll.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Commissioner Burke,
Aye.
Commissioner McCauley,
Aye.
Commissioner Givens,
Aye.
Commissioner Mettler,
Aye.
Chair Payne.
Aye.
Motion passed 8-0.
Vice Chair number 17, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Nicholas Smith may have violated ORS 192-660 sub 2 and ORS 192-660 sub 4, and the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on 17. Administrator, please call the roll.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
Aye.
Commissioner Halt,
Aye.
Commissioner Mettler,
Aye.
Chair Payne.
Aye.
Motion passed 8-0.
Okay, moving on to the next Crestwell, City of Crestwell matters, and also not appearing. So Investigator Fenstermaker, please provide the report.
Thank you, Chair Payne. Commissioners, I'm Casey Fenstermaker. The next set of preliminary review reports are regarding the City of Crestwell City Councilors. The alleged violations stem from a February 23rd work session. The complaint alleged that the City Council failed to provide virtual access to the entirety of the meeting, that the meeting minutes didn't reflect certain events that occurred, such as a recess, the issue with the virtual access, and an exchange between the mayor and a city councilor while on the record. The complaint also alleged city councilors engaged in serial communications during the recess and the time when the virtual access was unavailable. With respect to the allegations regarding serial communications, there was not sufficient evidence to establish that any serial communications actually occurred. With respect to the virtual access to the meeting, it does appear that the meeting was set to shut off at the 3-hour mark because they didn't anticipate the meeting going that long. Based on the evidence, it looks like the meeting continued for approximately 8 minutes before the city councilors and their staff realized that the virtual option and recording had ended. When they realized their error, they recessed the meeting and worked to restore virtual access. So, it's still a violation, but they did what they could to correct that at the time. When access was restored and the meeting began again, the mayor made a quick statement about what people online missed. So again, while there appears to be a lack of access, there also appears to be a violation because the meeting minutes didn't reflect those comments with respect to what occurred during the time that the meeting wasn't on the recording and the exchange between the mayor and the city councilor. Contrary to the allegations in the complaint, though, the meeting minutes are not required to note recesses, technical failures, or other kind of procedural issues. The reports recommend moving the cases to investigation because while it appears the city councilors did take steps to resolve the issues, there still appear to be sufficient evidence that violations of the law occurred, which is why we're recommending these cases be moved to investigation.
Commissioners, any questions for the investigator? Vice Chair.
What would you be looking for if we went forward?
There's really only one thing that I would be looking for, which is the city asserts that they have an audio recording. So much like we do the minutes, video, and audio, they said they have an audio recording, which captures the entirety of the meeting. So if they have that, then the issue of the meeting minutes is resolved, and their failure to adequately, reflect everything that was said in the meeting. That still doesn't take care of the fact that there's 8 minutes of the meeting missing from the virtual access. But again, they did what they could at the time to rectify the situation. So there's nothing I would want to look at there. That one is just kind of on its face the way that it is.
Thank you.
Investigator Fenstermaker, my understanding is that not every single thing that happens in a meeting must be captured in meeting minutes. Would you also be looking to see whether what was missed is something that's actually required to be in the
Yes.
minutes?
Yes, thank you for the question. Yes, absolutely.
Okay. Any other questions, Commissioner Halt?
Thank you, Chair Payne. My question is around technology. I am curious as to if we should have a interpretation of when there's a technological glitch, how we handle that. I feel like we have had technological glitches many times in our meetings and we fix them. But I feel like we're holding people accountable for things that they're not meaning to do or are out of their control. And this meeting coming off at 3 hours and then them quickly stopping the meeting and rectifying it, I really have no interest in moving that forward. I feel like there should be some sort of interpretation where we can say, it seems like you tried your best and you had a technology failure and there's a cure for it, if you will. But I don't know if we could come up with an official statement on how we could interpret that. But I feel like some of these cases that come before us could be dismissed on a technological glitch and a cure. And I am not interested in 192.670 parenthesis 2 or 192.670 parenthesis 3. I feel like that was a technology problem and they did their best effort to fix it, and I wouldn't want to move those forward. Thank you.
Thank you, Commissioner Halt. Commissioner Mettler.
If we were to go ahead and dismiss this, would we still be able to maybe suggest a letter of education? Or do we have to move it to investigation to get to the point of a letter of investigation? I mean, a letter of.
Yeah, the letter of education would follow if it goes to investigation and there's a stipulated final order. The letter of ed is the sanction. However, should the commission choose to dismiss, there is nothing that could prevent us from issuing a letter of advice or inviting them to take some of our public meetings law training or something along those lines.
Okay.
I feel like this was not just like a technical mishap. I feel like they set their meeting to end at 3 hours and the technology ended because they chose to do that. Their meeting ran long, but that was something that they could have avoided had they just done their settings differently. So unlike technology going down, I feel like that's something they could have avoided. So I'm inclined to move this forward because I do think a letter of education would be helpful in this circumstance, because it was an error that could have been avoided, rather than technology just simply crashing. And yeah, it's unfortunate, but again, it's not something that was just outside of their control. And that's where I'm leaning towards on this one.
Chair Payne.
Yes, Commissioner Gibbons.
Investigator, they had a recording, they said,
Yes.
but 8 minutes of that didn't get recorded because of the time set.
So they had a video recording.
Okay.
So the first video recording went the whole 3 hours. And you could see on the clock on the wall what time that ended, right? Then they had a second video recording, so you could see on the clock on the wall where that one started. So we knew that 15 minutes elapsed between when they ended their first one and started their second one, okay? When I talked to the city recorder, she indicated that her husband alerted her to the fact that the meeting had stopped about 8 minutes in. And so that's where that 8-minute kind of calculation comes from. The recording, so there are the video recordings, which are missing those 8 minutes, but they said they have an audio recording that captures the entirety of it. We just couldn't get it in time and listen to it in time to verify that those 15 minutes, well, the 8 minutes of the meeting and then whatever of the recess were captured.
So we won't know that until you give that.
Correct.
recording.
Yeah.
Thank you.
Vice Chair.
Thank you. So if that audio recording does exist, they would be covered? Refresh my memory on that one.
They would be covered with respect to the issue of the meeting minutes
Okay.
because they only have to have either the video recording, the audio recording, or the minutes capture the entirety of
Right.
the comments made at the meeting. They still have the issue of the lack of virtual access to online for folks for that 8-minute period. So even though there's a recording of it, people couldn't watch in the moment when it was ongoing. Sure, thank you.
Commissioner Halt.
Thank you, Chair Payne. My question is, did they speak to why the technology stopped at 3 hours?
Not on the recordings, but in my conversation with both the mayor and I can't remember if she was the city recorder or the city administrator, but either way, she indicated that it was set to 3 hours because none of their meetings ever go past 3 hours. So it felt like a safe period of time. And this one they were discussing very controversial issues and it just went longer than they were anticipating.
Thank you.
Thank you.
Any further discussion? Vice Chair.
Yeah, I mean, I'm prepared to make a motion to continue the investigation. I mean, I'm on the fence because I think this is, a part of me says this is really nitpicky, but the other part of me knows that public meetings law is nitpicky. So, I mean, so I think we should listen to the recording, see what's going on. I guess as this ends as a letter of education, but I think it's worthy of at least listening to the recording and figuring out what's what.
Okay.
Thank you, Madam Chair. I move the commission find there's a substantial objective basis for believing that Alonso Castilla may have violated ORS 192650 and ORS 192670 sub 4, and the commission should investigate accordingly.
Are these all separate?
Yeah, we
we
are
are
separate. Yes. Thank you for that question. Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 18. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Givens,
Aye.
Commissioner McCauley,
Aye.
Commissioner Halt,
Hey,
Commissioner Dancy,
Aye.
Commissioner Burke,
Aye.
Chair Payne,
Aye.
motion passed 8-0.
I think Hout was a nay.
She was an A.
She was a nay.
Oh, was she? I'm so sorry. Apparently can't hear today. Motion passed 7-1.
I move the commission find there's substantial objective basis for believing that Joan Morris may have violated ORS 192650 and ORS 192670 sub 4. Oh, no, that's not a sub on there, is that? That's a motion. I'm gonna rephrase that. ORS 192650 and ORS 192670, and the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 19. Administrator, please call the roll.
Commissioner Halt,
nay.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Dancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Gibbons,
Aye.
Commissioner McCauley,
Aye.
Chair Payne,
Aye.
motion passed 7-1.
Madam Chair, before we go to the next one, question for our council. I think on the first motion, I did say sub 4 on 192-670. Do we need to remake that motion?
I would remake that motion.
Okay. I self-reported, by the way, for the record. I move the commission find there is substantial objective basis for believing that Alonso Castilla may have violated ORS 192-650 and ORS 192-670, and the commission should investigate accordingly.
Okay, commissioners, we have an amended motion on number 18. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Gibbons,
Aye.
Commissioner McCauley,
Aye.
Commissioner Halt,
Nay.
Commissioner Jancy,
Aye.
Chair Payne,
Aye.
motion passed 7-1.
Vice Chair number 20, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Mark Kramer may have violated ORS 192-650 and ORS 192-670, and the commission should investigate accordingly.
Commissioners, you've heard the motion on agenda item 20. Administrator, please call the roll.
Commissioner Gibbons,
Aye.
Commissioner Halt,
Nay.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Chair Payne,
Aye.
motion passed 7-1.
Payne, I will be right back. Rest.
Okay. We still have a quorum, so.
Yep.
Moving forward, number 21.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Clark Kent may have violated ORS 192-650 and ORS 192-670, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on 21. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Halt,
Nay.
Commissioner Thompson,
Aye.
Chair Payne,
Aye.
motion passes 6-1.
Number 22, Vice Chair.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Alan Dukes may have violated ORS 192-650 and ORS 192-670, and the commission should investigate accordingly.
Thank you, Commissioners. You've heard the motion on number 22. Administrator, please call the roll.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Halt,
Nay.
Chair Payne,
Aye.
motion passes 6-1.
Vice Chair number 23.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Stacy Holt may have violated ORS 192-650 and ORS 192-670, and the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on 23. Administrator, please call the roll.
Commissioner Burke,
Aye.
Commissioner McCauley,
Aye.
Chair Jancy, I'm so sorry, Commissioner Jancy.
I got a promotion.
Aye. Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Halt,
Nay.
Chair Payne.
Aye.
Motion passes 6-1.
Vice Chair number 24, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Nicholas Smith may have violated ORS 192-650 and ORS 192-670, and the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on 24. Administrator, please call the roll.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Nay.
Commissioner Burke,
Aye.
Commissioner McCauley,
Aye.
Commissioner Mettler,
Aye.
Chair Payne.
Aye.
Motion passed 6-1.
Watch, we'll get another complaint. Something's been decided.
Before I made the last motion, I was gonna ask if I had Chair Jancy's permission. to-
Okay, let's see, where are we here? 21.
Thank you.
Committee 20. Seven has not confirmed, but 25 is attending. She's in the.
27 should be with 25.
Oh,
together.
They look at me.
This motion. Really hard.
Yeah.
Needs something.
Yeah.
It'll be a long one.
Warm up.
They are in.
Video. Ms. Armstrong, can you hear me?
Can you hear me now?
I can.
Okay, hi.
Hi, thank you so much for appearing today. My name is Chanel Payne and I am the chair of the commission. And I think is Terry McDuff also on the line?
Yeah, she's here with me.
Okay, wonderful. Okay, I just want to welcome you both and sort of provide the procedure of how this is going to occur. First, the investigator Sullivan is going to provide a report of the investigation, and following the report, the commissioners will have a opportunity to ask questions of the investigator. And then following that, we will provide you an opportunity to make a statement should you wish to do so. We ask that you keep that statement to 3 minutes or less, just because we're trying to get through a long agenda today. And then we will provide commissioners an opportunity to ask questions of you should they have any. And we will open it up amongst the commissioners to discuss this matter. And then we will vote on your matter. The decision that is being made today is whether to move this matter to investigation. There is no decision being made today as to whether any violations have actually occurred. I just want to make that clarification. That being said, we will now hear the report from Investigator Sullivan.
Yes, thank you, Chair Payne and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda items number 25 through 27. This is a complaint against the hiring committee for the city of Lakeside. The complaint alleges that the hiring committee acted without providing proper notice of their meetings, without recording or taking minutes of the meetings, and without providing public access to the meetings. And it alleges that the city website does not contain any information about how to submit grievances. The question here is whether the hiring committee qualifies as a governing body subject to the public meetings law. It appears that in a May 2025 recruitment for the city, the hiring committee was created to provide findings and recommendations to the city council, and the city council provided direction on how the hiring committee should proceed. When the hiring committee provided recommendations to the city council, and when they advised the city recorder in 2026, it appears that the hiring committee may have acted with authority to make recommendations on city administration and staff recruitment. Thus, it appears that the hiring committee may have been subject to public meetings law and their meetings should have been open to the public. Additionally, city staff acknowledged that the city website did not display the required information regarding the submission of grievances, and the website is being updated. Thus, it appears that they may have violated OAR 199-050-0070. And the information available appears to indicate that the hiring committee may have violated provisions of Oregon Public Meetings Law, and the recommendation is to move these cases to investigation.
Thank you, Investigator Sullivan. Commissioners, any questions for our investigator? Seeing and hearing none. Ms. Armstrong, now is the time for you to make a statement should you choose to do so. And we just, again, ask that you keep that statement to 3 minutes or less. I understand that Ms. McDuff does not choose to speak, but if you do choose to speak, we just keep that to 3 minutes or less. Thank you.
All right. Good afternoon, commissioners, and thank you. I'd like to make this brief statement. We acted in good faith, and it was never our intent to violate the open meeting law. I regularly call and check with the ethics office to make sure we are doing things correctly. Our city attorney stated we did not have to give notice because we were advisory to the administration authority only, and per our insurance company, CIS, we participated in the interviews to ensure the process was fair and equal. Lakeside is a small recreational retirement community. Our current council consists of 7 members, 3 of which have outside employment and normally cannot attend meetings during the day. 4 are retired. Of the 4 retired members, only 3 ever volunteered to help. That is why the formal hiring committee to hire the city recorder and the informal advisory hearing committee to hire office staff were the same members because no one else would volunteer. Under Sharon Barker, the pro tem city recorder, also the complainant, we helped with the recruitment and interviewing of the applicants. In September, after interviewing a wastewater applicant, Sharon Barker stated that per our city attorney, the city does not have to post meeting notices of interviews for city staff positions because staff employees were hired by the city recorder. Only the city recorder position had to be noticed. We told Sharon that while it may not be required to be on the safe side, we wanted her to continue to post notices of all hiring committee meetings and interviews. Sharon Barker failed to post the next 3 city recorder interviews. At our regular city council meetings, the hiring committee would give updates on the progress of the city recorder recruitment. In October, the whole council interviewed and unanimously selected Courtney to be our city recorder. Sharon Barker disagreed and showed a bias against the council selection and ordered the highest, most in-depth background check possible on Courtney. In November, Terry McDuff was appointed to the city council, replacing Adam Hand. In an executive session in January regarding potential litigation information, Courtney stated on advice from our insurance company she should not participate in the interviews involving Sharon Barker. Courtney reached out to the council and hiring committee and stated she wanted to temporarily reinstate the hiring committee to assist and provide input on the hiring of 2 positions because of her limited time with the city and under the direct advisement of the council. In January, Terry volunteered to do it. We interviewed. Sharon was not chosen and laid off. In February, Terry was under the consent calendar was ratified. And then March 30th and April 7th, the dates in question, the hire committee, along with Courtney, conducted 2 interviews. We each gave our opinions and thoughts, pros and cons in each applicant. We were very clear that these were our thoughts only because ultimately the decision who to hire was hers alone. She was building her team. When we left the interviews, we did not know for sure who Courtney was going to hire. And once again, per our attorney, we didn't have to notice the interviews because we were advisory to the administrative authority only, and all hiring authority was hers. Thank you.
Nicely done. Nicely done.
I timed myself. And I cut until I got it into 3.
That was impressive. Thank you. Thank you for that.
Did I make sense? Could you understand what I said? Because it didn't.
Yes, thank you.
Yes.
It's very helpful.
Yes.
Okay.
I'm going to open it up for commissioners to ask questions of our respondents, should they have any. Okay.
Any questions?
Vice Chair.
So I feel like they did everything right. This wasn't a quorum of the council because there's 7 of them and this was only 3. They reached out to their insurance company. They reached out to us. I feel like they did what they could do. And at this point, I'm just not feeling like I want to take this any further. And the thing for me is that the whole city recorder being, I know that the public officials are ultimately responsible for posting the minutes, but this one gets a little murky when the staff person responsible for it is also involved in the hiring and things can get funny. So at this point, I'm inclined to let this one go.
Chair Payne.
Commissioner Gibbons.
The term weaponization comes to mind.
Mm-hmm.
Some of this, and I have a tendency to feel somewhat like Commissioner Thompson that this is not anything to jump into.
Mm-hmm. Yeah, it does frustrate me when individuals get poor legal advice from their legal counsel and they act on that. It frustrates me. But I guess can Ms. Armstrong, can I ask you a question?
Yes, please.
You said and you were talking at a lovely speed. I appreciate that, but I think I might have got lost a little along the way. You said that you did notice some of the interviews, but then maybe later you did not for a second set of interviews. Is that correct?
Starting from the very beginning, when we were first appointed, we required everything to be noticed. And it was in the hiring, and I cut this down so much that we, and I have it in a timesheet where I had sent, previously I had sent it to make it easier for you, is it said that after we interviewed a wastewater employee, a wastewater applicant, Sharon made a big point of saying it's unfair to the applicants to have people in the audience watching. And she checked with the attorney, and the attorney says we don't have to notice. But up to that point, we had noticed every meeting. And then we said, well, we understand we don't have to, but we want you to, Sharon. So please notice everything. And then we find out when I was going through these records that Sharon didn't, I feel deliberately didn't notice the next 3 city recorder interview notices. She's the one that said that she knew that they had to notice the city recorder interviews and she didn't do it. But every time Allen and I came in, we would say, Sharon, was it noticed? And she goes, yes. Or she would mumble, and yes, whatever. So we assumed it was being done. Then when I was doing these things to pull up for Josh, I found that those 3 were not done. One was noticed, but it was never any records anywhere, but I had a copy of it. So it was lack of work on her part. So yes, we always noticed everything. And then once we hired Courtney, she checked with the attorney and CIS, and they says we do not have to notice. So at that point, I had turned everything over to her, and I assumed she was doing it correctly. Did I answer your question, or did I ramble?
Oh, so you answered my question. Thank you.
Chair Payne, I have a question for
Please.
why do you think these didn't get noticed? Was it just I forgot, or I was too busy, or was it done intentionally?
Okay, because this is not, well, I personally think she did it on purpose, because when we told her to notice everything, and she stated she knew that the only things that needed to be noticed was the city recorder interviews, why did the next 3 ones not get noticed? It doesn't make sense. But she would probably say she was too busy. I personally believe she's weaponizing the ethics committee against us. She is filing complaints, lots of complaints, and she's trying to make our lives miserable. Was that
Thank you.
appropriate for me to say?
Yes, thank you.
I personally struggle with a situation like this where it's the responsibility of the public officials, but they told their staff to do it. Their staff told them they did it. And what else were they supposed to do? I have trouble with this when they have to rely on and trust their staff to do what they tell them to do, and their staff tells them that they did it. It's one thing if they are simply relying on their staff to do it when they're not telling their staff to do it, but when they tell their staff to do it, and then they ask their staff, did you do it? And their staff says yes. To me, I feel like they've done all they can do. At that point, their staff just isn't doing their job. But I don't know. I mean, this is a tough one because do they have to also physically check that it's being done? I mean, I do know the buck stops with them, but it also just feels like it's that this is where I feel like the conversations we had earlier today about like reasonableness kind of sort of comes in, where like I think they were doing what they needed to do. Commissioner Halt?
Thanks, Chair Payne. I would support dismissal on this. I think that they did everything that they could do reasonably. Thank you.
Thank you, Commissioner Halt. I'm on the fence, but if somebody wants to make a motion,
I'll give it a shot.
okay.
For executive session, agenda items 25, 26, and 27, I move the commission dismiss the complaints against Elaine Armstrong, Alan Pointer, and Terrellyn McDuff.
Thank you, Vice Chair. Commissioners, you've heard the motion. On items 25, 26, and 27, Administrator, please call the roll.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
Aye.
Commissioner Halt,
Aye.
Commissioner Mettler,
Aye.
Chair Payne.
Aye.
Motion passed 8-0.
Okay,
Thank
Ms.
you.
Armstrong and McDuff, as you just heard, these matters have been dismissed, and we appreciate you appearing today and for your candor and your public service.
Thank
you very much.
Thank you so much. And we're learning, we're trying, so we'll get better.
Thank you. I appreciate that. Take care.
Thank you. Bye-bye.
Fair Payne.
Yes.
These are some of the issues that I had in the back of my mind about the pronunciation.
28 responded, 32 are here, so.
And 32 together first. Correct.
It should be up to both.
It's 17.
It is by phone.
By phone. Okay.
My
Oh, no, that's okay. Welcome back, Mr. Sterringer. I see that Ms. Massey is also appearing, and then I believe Mr. Sundin is appearing by phone. Is that correct?
Good afternoon, Chair Payne. I do see Ms. Massey on the screen. I don't represent Mr. Sundin, so I don't know whether he's on.
Okay, I see that he's just waived confidentiality, so he is appearing at this time. Sorry for that confusion. So we will proceed with hearing both your client's matter and Mr. Sundin's matter since he's waived confidentiality, but we will not hear the other matters at this time. Mr. Sundin, I see your hand. Is that your hand? Can you hear me? Somebody raising their hand. Mr. Sundin?
Chair, that is his number,
Okay.
*6 to unmute.
*6 to unmute if you can do that, Mr. Sundin.
No, it's supposed to be on. It's on.
Can you hear me?
Hello?
Hello. Okay, Mr. Sundin, as you
Can you
just
hear me?
heard, yes, we are going to hear Ms. Massey's matter and your matter right now. What is going to happen is the investigator is going to provide the report, and commissioners will have an opportunity to ask questions of the investigator. And then we will provide an opportunity for Mr. Steringer to make a statement, and then we'll allow you to make a statement should you choose to do so. We will ask each of you to limit your statements to 3 minutes or less, just because we have a long agenda to get through today. And then we will allow commissioners to ask questions of each of you should they choose to do so. Then we will open it up for discussion among the commissioners to deliberate this matter. And then the commissioners will vote on the matter. The only decision before the commission today is whether to move these matters to investigation. There is no decision being made today among the commission as to whether any actual violations have occurred. So I just want to be very clear about what is actually being decided today. With that being said, Investigator Patterson, please provide the report.
Thank you, Chair Payne and Commissioners. This is Investigator Silas Patterson for the record. I'm presenting executive session agenda items 28 and 32 in your meeting books. This is a public meetings law complaint against members of the St. Helens City Council. The complaint alleges that members of the St. Helens City Council may have violated Oregon public meetings law by excluding a member of the news media from attending several of the city's executive sessions from July 16th, 2025 through April 1st, 2026. In this case, it appears that the complainant, Brady Preheim, may qualify as a representative of the news media. However, it appears that the city's media policy was used to exclude Mr. Preheim from attending the city's executive sessions. The criteria and requirements outlined in the city's policy appear to narrow the scope of individuals who qualify as representatives of the news media and create barriers to media attendance at the council's executive sessions in a manner contrary to public meetings law as interpreted by the AG Opinion 8921 and the AG Manual. Thus, it appears that the council may have violated ORS 192.660 sub 4 when they use their policy and application procedures to exclude Mr. Preheim from attending their executive sessions. Additionally, on each occasion that Mr. Preheim requested to attend an executive session as a representative of the news media, other than a meeting on August 4th, 2025, it appears that the council failed to determine Mr. Preheim's news media status in open session. Thus, it appears the council may have violated ORS 192.660 sub 4. The recommendation in this case is to move to investigation.
Thank you, Investigator. Commissioners, any questions for our investigator? Vice Chair.
So just to clarify, when we heard this case, similar set of facts, we found that they did not make a determination.
Mhm.
It appears they have now made a determination, but the issue now is where the determination was made, whether it was made in open session or an executive session or not in any session at all. Am I getting that cascade of events correct?
Yes. So first of all, it appears that their media policy that they were applying to the situation was somewhat inconsistent with the AG opinion in terms of creating criteria that would narrow who or who could not be considered a representative of the news media. So that's kind of the first instance here. The second is that they did not make a determination on his status in open session prior to convening in an executive session at any of the meetings they held other than the one on August 4th.
So that is the second aspect, is failing to make that determination prior to convening an executive session.
Thank you.
Yep.
Thank you, Madam Chair.
Any other questions for our investigator? Okay, now is the time for statements. Mr. Sterringer, I assume that you're speaking for Ms. Massey? Okay.
Yes,
please
thank
limit-
you, Chair Payne.
Go ahead.
3 minutes is very short, but let me start with the issue of the question of when the council was making its decision in connection with this complainant, since that is what drew the first question. I think it's important to understand that the decision was made that this complainant was not a representative of the news media in a meeting that is the first meeting at issue. And the only question is whether the city council then had to make that same decision over and over again at ahead of every executive session that it had, because this particular complainant seeks entry to almost every executive session that the city council had. So there's a technical question there on whether they're required to do that over and over again. But there was a prior decision. There was no change of facts. And on that basis, we would encourage the commission to dismiss, because there was no reason for the city council to believe that the decision that they made in August of 2025 was incorrect as to this complainant after that. It's also the case that it is as clear as can be that this complainant is not a representative of the news media. He is a gentleman in the community who has a computer services business that is shown by his emails in connection with his grievances. He's a person who attends many city council meetings, and at almost every city council meeting, he's providing public comment, usually critical of things that the city is doing, either the city council or staff. That is, I only say that not because there's anything wrong with that, but it shows that this is just a member of the community and not a traditional reporter for an institutional news outlet. The city council here, following the last decision, sought guidance from council, sought guidance from the commission, took their obligations very seriously, and did what it could to comply with what the commission directed them to do in the last stipulated final orders. And frankly, we just don't know what else they could do to comply with those, given that we have an individual that under any definition of representative of the news media would not qualify. We'd be happy to answer any questions that you have.
Thank you, Mr. Sterringer. Mr. Sundin, would you like to make a statement?
Can you hear me okay?
Yes.
All right. I don't have a lot to add. I just wanted to mention that the last time we appeared, which I believe was March of 2025, appeared before the commission, my understanding was that it revolved around the fact that Mr. Preheim had been excluded from attending without a formal finding that he was not a media representative. And as was mentioned, since then, we have worked with our legal counsel and determined officially that Mr. Preheim is not a representative of the media. And nothing has been presented in the meantime that would change that fact. And in fact, I feel his case is worse, since the news station where he bought airtime has since cut ties with him. Despite his claims, our city does have media coverage, and a reporter for our local newspaper has been present at all of our executive sessions that I can remember in the recent past. Her organization applied, she met the qualifications and was granted access, and it's been great having her there. So this isn't about excluding those who qualify from attending. And honestly, if there's something that we could be doing better as a council, I would be happy to hear it. I do believe there's a purpose for executive sessions, and there's a reason that only qualified individuals are allowed to be present. And from what I have seen, Mr. Preheim does not meet those qualifications.
Okay, thank you. Commissioners, any questions for Mr. Steringer or respondent Sundin, Commissioner Gibbons?
What criteria does the council use as far as determining a valid media person?
Are you directing your question towards a particular individual?
To Mr. Steringer.
Thank you, Commissioner Gibbons. There is a policy that was adopted by the City Council following its last encounter with the Commission. And I'm thumbing through the materials because I believe it was included in the materials that were in front of the, that would be part of your packet. But I guess the best way I could describe it is that the commission, or I'm sorry, the city council took the criteria that were explicitly stated in the attorney general's opinion on this matter, and also referenced 3 other factors that they would consider in determining whether somebody is a member of the news media. And we highlight those in the letter that I sent on August 7th. They are that to look into whether the news media outlet distinguishes between fact gathering and opinion, whether the news entity is organized to support the terms of ORS 192.660 sub 4, and whether the entity has processes in place regarding conflicts of interest and error correction. And in our view, all of those factors would be consistent with a news media organization that is meant to be granted access under ORS 192.660. I will say again, as we said in our letter on August 7th, that the Attorney General opinion does not purport to create an exclusive list of factors that can be considered. And so the mere fact that they have additional factors that relate to the status of a news media outlet does not mean that it's an invalid policy. And in our view, what the commission should be looking at is the objective facts about this individual. And based on those objective facts, concluding that this is not a person who was a news gatherer for an institutional news media source. He's a person who had a weekly talk show on a radio station that was his, a spare time gig, and which the news media outlet itself, the radio station, disclaimed any relationship with in connection with the content that was produced. So unless every podcaster or blogger is going to be considered a representative of the news media, this person cannot be considered that. And the council appropriately decided that he should not be included in executive sessions.
Thank you, Ms. Steringer.
Commissioner Hill.
Thank you, Chair Payne. Can you speak to the 30 days submitted in advance of an executive session in the council's policy?
Yeah, my understanding is that and thank you for your question, Commissioner Held. My understanding is that what the city council was looking for was the ability to have enough time to review the information that was provided by the person who is seeking access to executive sessions to make the determination whether they're a member of the news media.
Can you speak to how long the council notifies the general public of their executive sessions?
The Mayor Massey might be able to speak more directly to this, but my understanding is that agendas and meeting notices are posted about a week in advance of the actual meetings.
Yeah.
And so if go ahead, I understand where you're going. I can probably speak to that if you'd like me to.
Yeah, go ahead.
Yeah, and I understand that could be an issue for the city council in the event that somebody showed up who had not gone through the process that the policy provided for. If they showed up at the executive session and asked to be recognized as media, without providing legal advice to the city on this, I think that it would be problematic for them potentially if they were to exclude somebody solely on the basis that they had not, provided the materials 30 days in advance of the executive session. That's not the facts that we have here, though. In this situation, we've got an individual who, for a very long time, has been trying to gain access to the council's executive sessions, and who went through the process and provided the information that was required. And that resulted in advice from the city attorney on whether that person was qualified as a representative of the news media, which then led to an official vote by the city council in an open session concluding that he was not.
Can I ask one follow-up question? Does the local newspapers attending the meetings, I heard from testimony, is the editorial board from the local newspaper allowed in these meetings?
I'm not aware of any instances when there has been a request for that to happen. And I'm seeing Mayor Massey shake her head no on that question. So that would have to be taken up on its own merits if somebody from an editorial board made a request for access.
Chair Payne, can I speak to this?
Please.
I find these rules particularly troubling. If the city's policy is that only fact, not opinion, that would mean editorial boards could not attend the meetings because editorial boards give opinions, not facts. And I think editorial boards are in most newspapers and should be allowed into the meeting per the Attorney General's guidance. I also find it particularly troubling that you would have to submit something 30 days before something that only needs to be calendared 1 week before. I don't know how someone would do that. It seems particularly targeted towards eliminating this particular journalist, media person. I also believe that journalism has changed tremendously and people are not necessarily affiliated with giant corporations anymore, and that they're not always their part-time, they're not always full-time journalists. I do believe that news media should be admitted, and I don't think the terms are the same as they have been in the past. I am really strong on making sure that we're transparent, and as traditional news media fails, we need to be more open towards not traditional news media. And one of the things that's very important when we're writing policies is making sure that we are not using, if we agree or disagree with how they're reporting, it should be equal access, in my opinion. And this case is very troubling to me. Thank you.
Thank you, Commissioner Howell. Vice Chair?
Sure. Thank you, Madam Chair. So I'm reviewing the policy for the city's media policy, and it's thorough. They have recognized a lot of media outlets. And if you're not recognized, there's multiple processes for you to get yourself recognized. So I think I commend the city in this policy because I think that not only do they take a lot of advice that we gave them into consideration, it looks to me like they've lifted parts of this policy directly out of the Attorney General's opinion on this. So I think this is above and beyond what, and without rendering legal advice, I would say that this is something that other cities might want to take a look at. As opposed to this particular case, I mean, my understanding is this gentleman purchased airtime on the radio station. Now, my business advertises on a local radio station. That I purchase airtime. That does not make me a member of the news media under any stretch of the imagination. So, and with the 30 days, I understand it. It takes time to review this stuff. And if I was a member of the news media that could cover the city council, when I got hired, I would go through this process and then it would be done. It's not like it has to be done every 30 days or has to be done for every meeting. This can be done, it sounds like once, and according to this policy, unless there's a change in status, you're good. So I don't know what more the city could have done on this thing. I mean, I know that we don't pass judgment on whether this person is a member of the news media, so I won't do that. But I think the city has done wonderful work on this policy. So, thank you.
Commissioner Givens.
Basically, Commissioner Thompson's covered the question I was going to ask, but so many of our public bodies, as far as news media goes, they recognize certain official news media to be involved in public government, whether it's posting notices, and those are recognized once a year, generally at the beginning of the year for that body. And for somebody to jump in at last minute, I've got questions about that.
I agree with Commissioner Halt on this in the sense that I have some concerns with drawing a hard line between fact gathering and opinion media in the policy, because I don't know that I think that would exclude a large area of media that should have access to executive sessions. And I'm not saying that the city doesn't have a good policy otherwise, but I'm concerned with a policy that draws that line.
Line in the policy? Where did I miss that line?
6 factors listed in section 2E of the city's media policy. The 3 remaining factors do not appear in the policy. The latter 3 factors appear in section 2E. Separation between fact gathering publications or broadcasts and opinion publications or broadcasts. That's on page 426 of our report.
I'm looking at the policy itself and I'm trying to find it. Oh, there it is. Okay.
So that's where I have my concern,
Okay.
mainly.
Good.
And Mr. Sterringer, I'll get to you in one second. I also have concerns that although I'm not saying this is exactly why the city would want to keep this individual out, it does sound like Mr. Sterringer stated that this individual regularly appears in front of city council, and I do not think that should disqualify someone as media. I do think that even media has rights to appear as a citizen in front of city council. If especially in a small town, they may have dual roles. Obviously, they can't both appear as a citizen and report as media at the same time. But you know, if they're appearing in front of city council, in one situation, I don't think that would disqualify them as appearing as media in another situation, especially in a small town like that, because they have First Amendment rights and should be able to speak as a citizen as well. And so there are just some things here that concern me enough to just get more information on this and move this to investigation, because I just have some questions around that portion of the policy and whether the decision was made because, you know, primarily on that opinion piece. So I just want to get some more information on that. Mr. Seringer, please.
Thank you, Chair Payne. On the 2 points that you made, let me take them in reverse order. With respect to the tendency of this complainant to appear and give public testimony at nearly every city council meeting, I didn't want to suggest that that was somehow part of the decision-making of the city that around whether or not he was a member of the news media. I thought that was helpful context for for the commission to consider in evaluating whether that is consistent with your understanding of what a reporter for an institutional news media outlet ordinarily would be doing on a meeting-to-meeting basis. So please don't read too much into that. That was provided for historical context. On the question of opinion versus news, straight news or factual reporting, I guess there are 2 things that I hope the commission would consider. One is that that is simply listed as a factor in the policy. It's not decisive, and so I wouldn't describe it as being a factor in which it's decisive, that if you fall on the opinion side, that means you don't qualify. It's not stated that way in the policy. It's simply one thing to consider. And I think it's appropriate to consider that because in the Attorney General opinion, it speaks to the fact that this exception for news media is primarily aimed at fact-gathering journalists for a news media outlet. And so to the extent that a person is a fact-gathering journalist, that is more indicative of their qualification as a membership of the news media, as opposed to something where there's a bright line that says if you are that, you're in, and if you're not, you're not. So those were 2 points. And then I guess the third point to your last point, Chair Payne, about gaining more information. The board's materials do include the city attorney's analysis of all of these factors and why she reached the conclusion that she did. And, you know, our view at least is that a fair reading of that analysis is accurate, that she made the right recommendation to the city council about whether this individual qualifies as a representative of the news media. So I wanted to make sure that the commission understood that all of that analysis is available to you today.
Thank you. For the sake of moving this matter forward, I'm going to just ask whether commissioners have any further discussion and try to move this closer to a decision on this matter. I'm leaning towards moving this to investigate Like I said, I have questions that I'd like answered. I'm not, I just don't feel like this is as clean cut as I would like it to be. So that's where I'm leaning. And if you don't feel comfortable making that motion, I'm happy to make it.
I'm leaning the other way. So
Okay.
I just to my thing, I would make a motion to, I'm not going to, but I would if I were making the first motion to dismiss this and then ask the city to reach out for a letter of advice. But until that, but I will hold mine until you're done.
And I don't mean to interrupt the commission's deliberations. I would like to say that the city attorney and I and Casey, we had a telephone conversation about, after the first case, about the AG opinion, what the criteria factors set forth in that opinion, and her intent to add additional factors that are not in the AG opinion. We, as a commission, as a state agency, are bound by the AG opinion. We can't apply factors that are not in the AG opinion. While they can adopt a policy, the AG opinion also says you can adopt whatever policies you want, but those policies cannot be used to exclude someone who would otherwise qualify as news media under the AG opinion. That's why when I looked at the 3 additional factors that got added to the policy, you know, there's the opinion versus fact one, but then there's sub E, which is a commitment and demonstrated structure to support the terms of 192.660 sub 4. That is about, should a news media member disclose the confidential information, would they be excluded from the next meeting? And the AG opinion very specifically says no. The fact that you mess up once doesn't mean we get to keep you out. And then sub F, a process in place for reporting conflicts and correcting errors, including violations of executive sessions statutes. The news media are not subject to our conflict of interest or executive session statutes. So this criteria made no sense to me. I mean, our dilemma here is that we have to apply the criteria in the AG opinion, and if they exceed those criteria, they may have that policy, but our AG opinion doesn't say that we can count that policy.
Just sorry to hijack, but just to Commissioner Helt's opinion about how things have changed since 2016, it would be interesting to me if it were possible for us to get an updated AG's opinion in light of the policy that St. Helens has, because this is an interesting policy to me. Now, I don't know, I'm not here to opine on the legality of it, it's not my job, but I would be interested in it, because Commissioner Helt's right, media has changed since 2016 and the last decade, and this policy seems reasonable to me. So, but we have to go by what the AG says. I understand that. So I'd be interested in an updated opinion in light of St. Helens policy.
Okay, I'm going to make a motion on 28 and 32.
McCullough's raising her hand.
Oh, Commissioner McCauley.
Thank you, Chair Payne. I was going to say, I'm happy to make those motions if that would be helpful to you.
That would be helpful. Thank you.
Okay, yeah, no problem.
Only 28, only 28 and 32, please.
Only 28 and 32. Perfect. Okay. I move the commission find there is a substantial objective basis for believing that Jennifer Massey may have violated ORS 192.660 sub 4, and the commission should investigate accordingly.
Thank you, Commissioner McCauley. Commissioners, you've heard the motion on agenda item 28. Administrator, please call the roll.
Commissioner Givens,
Aye.
Commissioner Halt,
Aye.
Commissioner Mettler,
Nay.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
No.
Commissioner McCauley,
Aye.
Chair Payne,
Aye.
motion passed 6-2.
Commissioner McCauley, agenda item 32, please.
I move the commission find there is substantial objective basis for believing that Brandon Sundin may have violated ORS 192.660 sub 4, and the commission should investigate accordingly.
Thank you, Commissioner McCauley. Commissioners, you've heard the motion on agenda item 32. Administrator, please call the roll.
Commissioner Thompson,
No.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Commissioner Burke, Commissioner Burke,
I'm sorry, the damn mute button. Aye.
Commissioner McCauley,
Aye.
Commissioner Givens,
Aye.
Commissioner Mettler,
Nay.
Chair Payne,
Aye.
motion passed 6-0.
Okay.
6-0.
No, no.
I'm sorry, 6-2. Thank you. I'm so sorry, guys.
It's okay.
Mettler and I matter.
Well, STEM education isn't what it used to be.
Mr. Steringer, Mayor Massey, and Mr. Sundin, thank you so much for appearing today. Staff will be in touch about next steps.
Thank you, Chair Payne and members of the commission.
No one else is appearing on the other matters? Or no?
We have to finish this matter.
No, I just
Okay.
mean on this one.
That
Okay.
is correct. No.
Okay. So, does the report stand or are they different?
They are identical.
Okay, so the report stands. So, Commissioner McCauley, can you make the motion on 29? You're muted, Commissioner McCauley.
Sorry about that.
It's
I
okay.
move the commission find there's a substantial objective basis for believing that Jessica Chilton may have violated ORS 192.660 sub 4, and the commission should investigate accordingly.
Thank you, Commissioner McCauley. Commissioners approved the motion on 29. Administrator, please call the roll.
Commissioner Mettler,
Nay.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Halt,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
No.
Chair Payne,
Aye.
motion passed 6-2.
Agenda item 30, Commissioner McCauley.
I move the commission find there is a substantial objective basis for believing that Mark Gunderson may have violated ORS 192.660 sub 4, and the commission should investigate accordingly.
Thank you. Commissioners, you've heard the motion on agenda item 30. Administrator, please call the roll.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
No.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Nay.
Commissioner Halt,
Aye.
Commissioner Givens,
Aye.
Chair Payne,
Aye.
motion passed 6-2.
Agenda item 31, Commissioner McCauley.
I move the commission find there is a substantial objective basis for believing that Russell Hubbard may have violated ORS 192.660 sub 4, and the commission should investigate accordingly.
Commissioners, you've heard the motion on agenda item 31. Administrator, please call the roll.
Commissioner Burke,
Aye.
Commissioner McCauley,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Nay.
Commissioner Givens,
Aye.
Commissioner Thompson,
Nope.
Commissioner Halt,
Aye.
Chair Payne,
Aye.
motion passed 6-2.
Okay, those matters are completed. We're still waiting for 30. Okay.
Okay, this is a cruel joke. That is a lot of OARs. You're like Silas all of a sudden.
No, I did argue with our legal counsel that it may be just the statutes, but I lost that argument.
Sorry, Commissioner. I mean, it seems we're blaming everything on the Attorney General's office today, so I mean, why should we stop now?
That's right. I
Can I
stubbed
ask
my
a
toe
quick-
a little bit earlier and blame the Attorney General's office as well.
His fault.
So when you're making a motion, if that happens again where the vice chair doesn't want to make a motion, it happened last time. And I was gonna make a different motion, but I didn't have a motion in front of me. Is it that I go to the preliminary review report and use the recommendation and make a motion that way?
There's a motions sheet in your materials with all the appropriate motions. So you use the motions sheet and the appropriate motion is listed by each one. So when it says 4 at the end, that's the motion you would make. If you want to make that motion, otherwise you look for the motion to dismiss motion. So.
Chair, the respondent 33 said that they needed 2 minutes when we called them. So it is up to you whether or not you
If you wanted, you could proceed up to items 39 and 40.
Yeah, let's
And
go
then
to
come back.
40. I don't want to wait. Fair, so.
My iPad is clock on it. That's a mistake.
Our meeting is scheduled to end at 4, so.
Better not.
What?
They're not gonna go over.
4:08. We have a problem. I think.
Okay. Okay, so no one is appearing on 39 and 40, and we have got Investigator Pacheco. Please proceed.
Thank you, Chair Payne and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda items 39 and 40 in your meeting books are preliminary review reports for Deborah and David, members of the Prineville Lake Acres 1 Special Road District Board of Directors. The complaint in this matter concerns 2 district board meetings held on March 23rd and April 24th, 2026. Based on the information gathered, it appears that the board violated various provisions in RS Chapter 192 at the March 23rd and April 24th meetings. In this case, the public meeting notices failed to 1, satisfy the requirements of providing the public with principal subjects anticipated to be discussed, or the place where the meetings would be convened. 2, notify interested persons or members of the news media of the meetings. 3, provide the public with information on how to contact to request an interpreter or other communication aids. And 4, provide the public with virtual or other electronic means to attend the meetings. Additionally, it appears that the board failed to provide a written response to the March 23rd grievance within the required response deadline as required by statute. In doing so, it appears that the board members violated ORS 192.640 sub 1, ORS 192.670 sub 3, ORS 192.705 subsection 2, OAR 199-050-0040, and OAR 199-050-0070. And the recommendation in your books is to move these cases to investigation. Thank you.
Thank you, Investigator Pacheco. Commissioners, any questions for our investigator? Any discussion? Vice Chair, are you prepared to make your long motion?
Yeah, everybody pack a lunch. Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Deborah Kowalski may have violated ORS 192.640 sub 1, ORS 192.670 sub 3, ORS 192.705 sub 2, and OAR 199.050.0040, and OAR 199.050.0070, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 39. Administrator, please call the roll.
Commissioner Burke, Commissioner Burke. We'll come back to him. Commissioner McCauley,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
Aye.
Commissioner Halt,
Aye.
Commissioner Burke. He does not appear to be online at the moment. Okay. Then Chair Payne.
Aye.
Motion passed 7-0.
I move the commission find there is a substantial objective basis for believing that David Chamberlain may have violated ORS 192-640 sub 1, ORS 192-670 sub 3, ORS 192-705 sub 2, OAR 199-050-0040, and OAR 199-050-0070, and that the commission should investigate accordingly.
Okay, commissioners, for the motion on agenda item 40, administrator, please call the roll.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Halt,
Aye.
Commissioner McCauley,
Aye.
Commissioner Givens,
Aye.
Commissioner Mettler,
Aye.
Chair Payne.
Aye.
Motion passed 7-1. I'm sorry, 7-0.
Thank you.
World today.
Are we doing okay, or do people need a quick break before we go to the next set?
I think we're doing okay. You can do number 41, which is related, but
Oh, 33 is in the waiting room.
okay. 41 is a dismissal.
I'll make it quick.
Okay, let's go to 41.
Let's do it.
Thank you, Chair Payne and Commissioners. This is Investigator Deanna Pacheco for the record. In this case, because Mary was not a member of the road district during the period relevant to this preliminary review, the recommendation in your meeting books for agenda item 41 is to dismiss. Thank you.
Any questions for the investigator? Any discussion? Vice Chair?
Thank you, Madam Chair. For executive session, agenda item number 41, I move the commission dismiss the complaint against Mary Shinzeki. Schnetsky. Against Mary.
Okay, commissioners, for the motion on 41, administrator, please call the roll.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
Aye.
Commissioner Halt,
Aye.
Commissioner Mettler,
Aye.
Chair Payne.
Aye.
Burke has rejoined the meeting. Excellent. He's back. Commissioner Burke.
I'm going to abstain from this vote because I was disconnected.
Motion passed 7-0 with one abstention.
Okay, going back to the 33 through 38 matters.
I'm going to admit 33, they're calling in by phone. And they are on *6 to unmute. *6 to unmute.
Mr. Starr, can you hear me? Can you *6 to unmute?
Can you hear me now?
I can. Mr.
Okay.
Starr, we are here this afternoon to hear these matters regarding you and a few others regarding Alfalfa Fire District. We will have a report, and then after hearing the report from the investigator, commissioners will have an opportunity to ask questions of you. And then, they will have an opportunity to ask questions of the investigator, and then you will have a short opportunity, 3 minutes or less, to provide a statement, and then commissioners will have an opportunity to ask questions of you should they have any. Following that, we will open it up to deliberation and discussion amongst the commissioners. And then the commissioners will vote on this matter. The only decision being made today is whether to move this to investigation. There will be no decision being made today whether any actual violations have occurred. I just want to clarify that. And that being said, we will now hear the report from the investigator, Investigator Sullivan.
Yes, thank you, Chair Payne and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda items 33 through 38. This is a complaint against the Board of Directors for the Alfalfa Fire District. The complaint includes 2 grievances alleging that the AFD board may have violated Oregon Public Meetings Law on multiple occasions in 2025. The information available during preliminary review appears to indicate that the board may have failed to provide timely notice of their meeting on April 9th, 2025. Specifically, the Prineville Review received notice via email at 5:20 p.m. on April 9th, approximately 40 minutes before the meeting 6 p.m. start time, and it is unclear when the public notice was posted. It also appears that the board may have anticipated that they would discuss, consider, and sign specific resolutions during their April 9th meeting. However, the agenda did not include any information about the resolutions scheduled for consideration. It appears that the meeting notice for April 9th, November 12th, and November 19th, 2025 failed to include information on how to request an interpreter or other communication aids. And it appears that the AFD did not post on its website the required information regarding the submission of grievances. The information available appears to indicate that the board may have violated multiple provisions of Oregon Public Meetings Law, and the recommendation is to move these cases to investigation.
Thank you, Investigator Sullivan. Commissioners, any questions for the investigator? Okay, Mr. Starr, now is the time for you to make a statement, should you choose to do so, and we just ask that that statement be limited to 3 minutes or less.
Okay, perfect, thank you. First off, the one thing about this is when we received a grievance from aldermen about not doing something right, he didn't get this, he didn't get that, we immediately changed things. So after reading this report, you're going back to November and April saying that we didn't do something, or we didn't do enough, or we didn't do this or that. All of this has been changed, and this was submitted on May 27th. So I'm not sure what we might have violated back in 2025, but it has all been addressed and adjusted to where the ADA, if you need to get an interpreter, that has been added to the website. Our chief, Chadley Valley, our previous chief, because his contract ran out, he was the one that was in charge of putting all this information out to the public to submit or post agendas and or meeting times and stuff. So I didn't have any control over that. That was all Chief LaValle. So the one about, not getting it done in time, I believe there's a discrepancy that we sent it to the quote, Prineville Review, but we did not send it to Justin Alderman's personal email. And that's what he was complaining about. We did notify the Prineville Review, according to talking with Chad about what happened. But it was a discrepancy of Alderman wanted it to his personal, including to the Prineville Review staff. The other thing is the one thing and first most thing is I look on this very front page and it says the Alfalfa Irrigation District. He's also, so he sues and throws complaints against so many people that he doesn't even know who he's trying to sue and who he's trying to get an ethics complaint against. So the front page says Alfalfa Irrigation District, but in parentheses it says AFD. So I would like to take that into consideration also. And the way that he presents it, I feel it's a misrepresentation of the truth, leading the ethics committee to believe that we're not doing anything or correcting anything, which we are, because we've also had our legal counsel there the entire time. And when we started getting these grievances, legal counsel helped us identify what needs to be done correctly. So we're meeting public meeting law requirements, and we make the changes and alterations right away. But ethically adding this in November or March 27th for grievances that were already corrected, I'm not sure ethically what that is going to gain or what the purpose of trying to get the alfalfa maliciously attempt to get or scorn or tarnish the Alfalfa Fire District even more than what Alderman has done. I'm going to leave it at that because I'm no longer on the board. I quit on May 9th in a public meeting, have no control. influence or persuasion on what the current board does now. And so I'll end my statement with that.
Thank you, Mr. Starr. Commissioners, any questions for Mr. Starr? Vice Chair, question for staff.
So Mr. Starr says that the issues that the complainant complained about have all been corrected as part of the, will we take that into account as part of, if we move it to investigation, will that be part of what you look at?
Yes, thank you for the question. Certainly, we are looking at that, and for the portion of like updating the website and including information on how to contact them for interpreter communication aids, that's something we would work with them to correct. Some of this stuff is from 2025 and notices that have already gone out, and so if it went to investigation, there wouldn't be corrective action that could really be taken at this point, but is something that would probably lead to a letter of education about those notices that took place in 2025.
Yeah, he says they've got legal advice, which obviously is part of our matrix, but.
I would also point out that in the matrix, there is a mitigating factor point awarded if they have taken corrective action.
Perfect.
Even after the grievance stuff is done.
Thank you.
I have another question. For public meetings law violations, they can respond to the complaint saying what corrective action they've taken.
Yes.
And if that had happened, we could dismiss, correct?
Yes, if we found that the corrective action was reasonable in light of the circumstances, the commission, in fact, might be required to dismiss at that point.
Okay, so I guess I'm unclear why they wouldn't have just done that in this case. Why would, if they had taken corrective action, maybe I should ask that of Mr. Starr. If all corrective action had taken place at the time the complaint was received, then why wasn't the statute followed and the response to the complaint provided with all the steps taken to have corrected the violations?
All of them were. We sent responses to every grievance letter that aldermen sent to us, with Jared Reed, the district lawyer, reviewing the responses to be able to send to him, along with the corrective action that we did, and stating that we would, put the website, update the website to be able to have interpreter services and contact personnel at the station. And all of those things were addressed in every grievance letter response sent to aldermen. And that's kind of like, I'm wondering how it even got this far, because again, I will state that I feel he is maliciously leaving information out and using false pretenses to continually to tarnish Alfalfa Fire District with these accusations that he makes, but all of it has already been corrected. One of the things that I went through and pointed out in my notes here is we, for 12 years, left our agenda with minimal information. One thing that he complained about of ambulance update. Okay, that was an ambulance update. Where are we at on getting it certified with the state of Oregon? For 12 years, our agenda, setting a precedence, did not have detailed information. Once his grievance came in that it didn't have detailed and Oregon Public Law submitted it, that it should have more detail, the agenda's changed to add more detail to each individual bullet point in that situation. Again, I state that how this got to the point where it is he leaves out pertinent information, ethically questioning his reason to submit it on May 27th of this year, when all of it was corrected in 25 and early 26.
Okay, thank you. So they have to admit the violation and then say how they're going to cure it. And it doesn't seem like they did that. They only did that as to the website violation. Okay.
I know that, excuse me for interrupting. I know that I personally reviewed and read at least 6 to 7 different responses to grievances that went back to aldermen.
Okay, thank you, Mr. Starr.
Sounds to me like we need some more
Yeah.
information here, because because I don't know that we have those grievances, so it might be nice, or grievance responses, it might be nice to get those.
I'm seeing 2 in here, but they have to admit the violation in order for it to be the kind of thing that would dismiss it. So, okay, that answers my question. Anybody else have any questions? Discussion? Vice Chair, you prepared to make a motion?
I am. Thank you, Madam Chair. In the spirit of getting some more information to figure out a little more about what's going on here, I move the commission find there is a substantial objective basis for believing that Nathan Starr may have violated ORS 192-640 sub 1, OAR 199-050-0040 sub 3, OAR 199-050-0040 sub 4, and OAR 199-050-0070 sub 3, and the commission should investigate accordingly.
Commissioners, you've heard the motion on 33. Administrator, please call the roll.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
Aye.
Commissioner Halt,
Aye.
Commissioner Mettler,
Aye.
Chair Payne,
Hey, baby.
Aye.
motion passed 8-0.
I move the commission find there is a substantial objective basis for believing that Mark Lacus may have violated ORS 192-640 sub 1, OAR 199-050-0040 sub 3, OAR 199-050-0040 sub 4, and OAR 199-050-0070 sub 3, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on 34. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Givens,
Aye.
Commissioner McCauley,
Aye.
Commissioner Halt,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Chair Payne,
Aye.
motion passed 8-0.
35.
I move the commission find there is a substantial objective basis for believing that Carolyn Chase may have violated ORS 192-640 sub 1, OAR 199-050-0040 sub 3, OAR 199-050-0040 sub 4, and OAR 199-050-0070 sub 3, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on 35. Administrator, please call the roll.
Commissioner Halt,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
I'm sorry, aye.
Commissioner Givens,
Aye.
Commissioner McCauley,
Aye.
Chair Payne,
Aye.
motion passed 8-0.
36.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that that Dustin Peugeot may have violated ORS 192-640 sub 1, OAR 199-050-0040 sub 3, OAR 199-050-0040 sub 4, and OAR 199-050-0070 sub 3, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on 36. Administrator, please call the roll.
Commissioner Givens,
Aye.
Commissioner Halt,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner McCauley,
Aye.
Chair Payne,
Aye.
motion passed 8-0.
37.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that David Pike may have violated ORS 192-640 sub 1, OAR 199-050-0040 sub 3, OAR 199-050-0040 sub 4, and OAR 199-050-007-0 sub 3, and that the commission should investigate accordingly.
Commissioners, heard the motion on 37. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Halt,
Aye.
Commissioner Givens,
Aye.
Commissioner Thompson,
Aye.
Chair Payne.
Aye.
Motion passed 8-0.
38.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Beth Weiss may have violated ORS 192-640 sub 1, OAR 199-050-0040 sub 3, OAR 199-050-0040 sub 4, and OAR 199-050-0070 sub 3, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on 38. Administrator, please call the roll.
Commissioner McCauley,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Halt,
Aye.
Commissioner Givens,
Aye.
Chair Payne.
Aye.
Motion passed 8-0.
Investigator Fenstermaker, please proceed on items 42 through 44.
Thank you, Chair Payne. Commissioners, this is Casey Fenstermaker for the record. The preliminary review reports for agenda items number 42, 43, and 44 are regarding 3 Portland City Councilors who are also members of the city's Public Works Committee. Mitch Green, Samir Kanal, and Tiffany Koyama Lane. The committee members all attended a town hall event where they discussed matters that could potentially come before the Public Works Committee. And since the 3 of them constitute a quorum, a grievance was filed alleging that the committee members engaged in an illegal meeting while participating at the event. The city issued a response admitting that the committee members discussed matters that could come before the committee and described their effort to cure it, pursuant to ORS 192.685. To cure the alleged violation, at a full city council meeting, each of the city councilors who had attended the event spoke about attending the town hall event and entered a transcript from the event into the meeting record. Second part of the cure was forward-looking, and the city's response set forth options for city councilors and committee members to handle similar issues going forward, such as noticing the town hall as a committee meeting, public meeting, or avoiding attendance of a quorum at such an event. Alternatively, if a quorum of the committee or a committee is attending an event, the members could make it clear at the start of the event that if a topic arises that may come before the committee, they might not be able to discuss that matter. The complaint alleges that the forward-looking cure was insufficient because it presented alternatives instead of a definitive fix. In reviewing the actions taken by the city councilors and the proposals for preventing similar violations in the future, they all appear to be reasonable. As such, we are recommending dismissal in these cases. Thank you.
Thank you, Investigator Fenstermaker. Commissioners, any questions for the investigator? Any discussion? Vice Chair.
Thank you, Madam Chair. For executive session items number 42, 43, and 44, I move the commission dismiss the complaints against Mitch Green, Samir Kanal, and Tiffany Koyama Lane.
Commissioner Hell.
I have some discussion.
Okay. Hold that motion.
How about
Sorry
this?
about
Withdrawn.
that.
Withdrawn. Okay,
Withdrawn.
motion withdrawn.
Sorry
Proceed.
about that. I'm particularly frustrated with this set of counselors as they were referred to themselves as the Peacock Club in our December 12th meeting and had issues with serial meetings as well. And they just came off of having a letter of education, and I'm not sure that they understood the letter of education. I understand that they cured the problem, but I'm really frustrated that they are doing the exact same behavior with the same folks a second time after the letter of education was issued, and I don't know the date the letter of education was issued. Maybe someone on the staff that issued that could tell me when, but it's a little frustrating. I don't think they're taking their serial meeting education very seriously.
Commissioner Hell, maybe somebody can correct me if I'm wrong, but those matters against the city of Portland Peacock committee were dismissed. So I'm not sure what maybe you're remembering something else?
Oh, we didn't issue a letter of education because it says in here that they had just gotten a letter of education in here.
I'll
I
add
could
that I
be wrong.
handled the initial complaint that I believe you're referring to for the retreat back in August. And that case, while it was moved to investigation, the investigation reports determined that there was not a preponderance of evidence for any of for a meet in private or serial communications. Thank you.
Okay, I guess I stand corrected on the letter of education.
I would just like to clarify, under 192.685, if the commission finds that they did reasonably cure the violation, or whatever steps they took to cure it were reasonable, then under 685, the commission doesn't have jurisdiction to proceed.
Okay.
Oh, your decision here would be, was making the announcement and putting everything into the record at the next public meeting, and then adopting procedures moving forward. Was that a reasonable cure of this violation?
Okay, thank you for the clarification.
Would you like to remake your motion?
Well, thank you, Madam Chair. For executive session items number 42, 43, and 44, I move the commission dismiss the complaints against Mitch Green, Samir Kanal, and Tiffany Koyama.
Thank you, Vice Chair. Commissioner, you've heard the motion on matters 42 through 44. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Gibbons,
Aye.
Commissioner McCauley,
Aye.
Commissioner Halt,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Chair Payne.
Aye.
Motion passed 8-0.
Okay, I'd like to just do these last two matters before we take a break, unless anybody's dying. Pretty okay? All right. Do I have to restate I already stated the authority. Do I have to restate it?
It might be one, we have to have new recordings set up. And it would probably be a good idea.
Okay. Okay, we're ending the first executive session and entering the second executive session being held to consider information relating.
Hold on one sec. Just 1 second, we need to